reading out names after names for the list, but there was not a single member present, unquote. I hope the defaulting members are at least not paid the day's sitting fees. This is my comment. In the above background, the former Speaker of the Lok Sabha, Shri Somnath Chatterjee, pleaded for the right of the voters to recall their representatives. He has quoted in an article recently published in Deccan Herald under the headings Legislators Hazir Ho, that the voters must have power to recall. In that article, Honorable Speaker has stated, and I quote, legislators seem to forget that there is more to winning elections than just enjoying the perquisites. They have a duty towards the Constitution, the nation, and the people. The least they can do is to behave properly inside the House. But they are aware that once elected, practically nothing can shake them from their position. This is one of the reasons why they begin behavior in a manner highly unbecoming of them, unquote. It is in the above background I am constrained to question what is left of democracy in legislature. Let me now consider the state of affairs amongst the executive, that is the bureaucracy, which is also a constitutional organ. As noticed by me in the earlier part of this lecture, the constitutional framers wanted to elevate the status of bureaucracy from statutory to constitutional. It is in this view, in part 14 of the Constitution, it is provided for recruitment of service conditions and members of the executive. Constitution has given a guarantee to the members of the executive in regard to their tenure in office. Even their removal from misconduct has been protected by the certain procedural guarantees. Unlike the legislature, the members of the executive are required to have minimum educational qualifications, and to get the best of talent, aspirants of this institution has to undergo a process of selection and are subject to various trainings at entry stage and also during their course of service. Special institutions of administrations were established to impart training in the administration, so that the country could have the benefit of trained administrators. While the legislature was empowered to make laws and policies for governance of the state, the burden of administering these laws and policies is with the bureaucracy, right from the British days. The bureaucracy in India had very high reputation integrity-wise. Exception to the rule were far and few. It was the desire of the constitutional framers that the standard of bureaucracy should be such that the country can expect an impartial, a political, and a people-friendly bureaucracy. In the first 2 decades of our democratic setup, at every hierarchy of bureaucracy, maybe with a small exception, the probity and efficiency was forthcoming. The members of the executive maintained dignity of office and worked with the framework of law. It respected the other 2 organs of the Constitution. There was zeal amongst the members of the bureaucracy to work even in remote areas with concern for the downtrodden and the deprived. The bureaucrats have always been paid well. Their remuneration is fixed in consonance with the rise in price index by creating independent pay commissions. The Constituent Assembly, while discussing the draft Article 282B, which is presently Article 309, showed great concern about the security of tenure of the members of the executive, as also what should be the relationship between the political bureaucracy and the executive bureaucracy. To deal briefly with this subject, I would like to quote from the address of Mr. Vijay Prasad, and he said, and I quote, "Power of dismissal, removal, reduction in rank of persons employed in the several age capacities under the Union or the state should be in the hands of the Public Service Commission. I want that disciplinary matters should not rest in the hands of ministers, either central or provincial. Sir, I am not in any way suggesting, of course, a course of action which has got no precedent in any part of the world. In Great Britain, in Canada, in Australia, and in South Africa. In all these countries, the public servants are not under the ministers, and there has been no conflict or no confusion of authority. In the circumstances in which we are placed today, I am quite clear in my own mind that if foundations of our civil service are not to be laid on sound and scientific basis, they must be removed from the control of the ministers. The independence of bureaucracy from the control of the ministers is as important, if not more, than the independence of the judiciary from the executive interference. The role of public servants, according to my humble judgment, is more important than that of the ministers. Men may come and men may go, but I go on forever. The public servants remain though ministers may come in and go out of the cabinet and bewildering rapidity. The foundations of our national life can be secured if the public servants are assured of their security, if they get conviction that there will be no ministerial interference for no fault of theirs. If they do not find favor with the ministers, they are transferred to some unknown regions in some God-forsaken district. This creates a sense of insecurity. I am quite clear in my mind that there is need for administrative unification of the country. Sir, I am of the opinion that all the civil servants should be brought under the control of the Union Public Service Commission. As a matter of concession, I am prepared to agree that some control should be vested in the hands of the State Public Service Commission. I stand for the proposition that the civil servants of India, whether central or provincial, should be under the Central Public Service Commission. We are passing through a very difficult period. Sir, the whole of our society is passing through a period of decay. And if you want the birth pangs of the new social order should be prolonged, we should lay the foundation of our civil service on the safe and secure basis. Many of the sentences in the above address of Sri Vijeshwar Prasad sound prophetic today. The request of Vijeshwar Prasad was not only not fully accepted by the Constituent Assembly, though it did provide for some sort of separation of power, the relationship between the political bureaucracy and the executive bureaucracy became somewhat similar to the relationship between the master and the servant over the period of time. When I say the political bureaucracy, I mean the cabinet of that time. Cabinet misutilizing the power conferred in the conduct of government, rules of conduct, conduct of government business rules, practically usurped very many powers that were vested solely with the executive and started controlling the executive, which in turn succumbed to this pressure. Consequently, the decision taken by the government got tainted with political color. Many of the bureaucrats, fearing uncomfortable transfers, became subservient to the cabinet, which was what Mr. Vijeshwar Prasad in his speech dated 8 September 1949 had apprehended. This change in the system of functioning literally took away the accountability in administration. With the passage of time and political instability becoming a common thing, cabinet itself started becoming subservient to other elected representatives, which gave a dominant role to all elected representatives to control the executive. This change caused very serious damage to the bureaucratic administration. The elected representatives started demanding officers of their choice in their constituency in the guise of bringing about development in their constituency. Knowing the disadvantage of being in good books of an elected representative, many of the officers started cultivating the elected representatives. Consequently, today, politics in administration has percolated from top to bottom of bureaucracy. This drastic change in the administration of the state has serious repercussions on good administration. Worse still is the corrupt nexus between the politician and the bureaucrat has become deep-rooted. As I once said in a lecture of mine, legislators and bureaucrats have become conjoined twins. Of course, there may be exceptions to this rule. They are conjoined twins because one cannot live without the other. There cannot be maladministration and corruption if one of them opposes the other's illegal acts. Factum of such unholy alliance is well known. The quote from Honorable Prime Minister and Honorable Vice President proves this point. Even within the bureaucracy, we find an admission of large-scale corruption in its institution. A few years back, it was reported that an IAS officer in Uttar Pradesh was identified and ranked as the most corrupt amongst them in the list prepared by the Association of IAS Officers of the state. The exceptions of the Constitution framers, the expectations of the Constitution framers of an honest, people-friendly executive has become an exception and not a rule. If that is so, what is left of democracy in executive? I would now consider the situation in the Indian judiciary, which is also an organ in the Indian Constitution. Earlier, I had commented that Indian judiciary is one of the bedrock of the Indian Constitution and to maintain its independence. The Constitution has insulated this institution from external interferences. The question now is whether judiciary has really lived up to the confidence reposed on it by the constitutional framers. The concern of the members of the Constituent Assembly is well reflected by the words of Sri M. Ananthashayanam Iyengar, who participated in the debate on the establishment and constitution of the Supreme Court on 24th November 1949. Sir, quote, sir, we have now reached the discussion of this constitution at a stage which, according to me, is one of the most important stages, if not the most important stage in the discussion of the constitution. Supreme Court is the watchdog of democracy. In an earlier part, we have enacted the fundamental rights, and we are very anxious to provide the means by which these fundamental rights could be guaranteed to the citizens of the Union. This is the institution which will preserve those rights and secure to every citizen the rights that have been given to him under the Constitution. Therefore, naturally, this must be above all interference by the executive. The Supreme Court is a watchdog of democracy. It is the eye and the guardian of the citizens' right. Therefore, at every stage, from the stage of appointment to the judges, their salaries, the tenure of office, all these have to be regulated now, so that the executive may have little or nothing to do with their functioning. The provisions that have been made with an eye towards that. If amendments are moved now, each amendment must be judged by the test whether it secures the independence of judiciary, which this chapter attempts to provide for. While discussing the draft Article 15, which is present Article 21 of the Constitution of India, very many speakers have reposed confidence in the judiciary to protect the nation in the event of failure of legislature at the time of crisis. Some of the speakers who had foreseen possibilities of a single party gaining total majority in the democratic system and destroying the very constitution under which the legislature itself is constituted, argued that it is the judiciary that will come to the aid of the nation when the legislature fails to maintain democracy. What was apprehended during the framing of the Constitution did happen in the year 1975, when an attempt was made to sabotage the democratic system. Though the superior judiciary, that is the high courts, did their best to protect the democratic system, sadly, apex court failed to do so. But fortunately, wisdom dawned on the political leaders sensed the simmering public opinion, and democracy was put back on rails. Apart from the above single sad incident, by and large, Indian judiciary played its role as expected in the Constitution for a long time than the other two organs of the Constitution. For a long time after India became republic, judiciary was the most respected institution. When property declined in other two organs of the Constitution, people felt that judiciary is there to protect them. Till about the decade of ending with 1980, the judiciary was the most respected institution in India to solve the problems of the people. Even the politicians and members of the bureaucracy approached the judiciary for redressal of their grievances. Judges at all levels, especially at the higher courts level, were revered and respected, even though at that point of time there were some black sheep in the institution of judiciary. Their presence was ignored as some aberration. The institution as a whole held its head high with pride. The decline in judicial property came to be noticed starting from the decade of 1990. The first case which made news was the impeachment proceedings of a judge of the Supreme Court in early 1990s. But the Supreme Court in that case took timely action. The move for impeachment failed because of the failure of the legislature or the parliament. Thus the judge concerned escaped punishment. I call it an opportunity missed. For this fault of the parliament, judiciary cannot be held responsible. Maybe this failure on the part of the legislature encouraged some more in the judiciary to indulge in activities which started sabotaging the reputation of the judiciary. In this process, judiciary also committed mistake by concealing the lack of individual probity, which was noticed in some cases with the hope it will not be repeated. Instead of taking action against the erring judge, maybe thinking that any action taken publicly would damage the reputation of the institution. This hushing up turned out to be undoing of probity in judicial system, which in my opinion contributed to the fall of honesty in judiciary. This position continued when the first time the Superior Court, if in early 80s there were to be open debate about the happenings in the judiciary, same I'm sure would have halted the fatal fall in the standard of judicial probity. Unfortunately, that did not happen. Thus, the judiciary lost an opportunity to redeem itself in the constitutional hierarchy. At that time, information and suspicions were dismissed as mere rumors. In this context, what Mr. Sabyasachi Mukherjee, who was a Chief Justice of India in early 1990, stated in the case of Justice V. Ramasamy is very relevant. And I quote the facts leading to the same. and the reaction of then the Chief Justice of India in 1990. When Justice V. Ramaswamy was sitting judge, the reports started circulating about various questionable acts of Justice Ramaswamy when he was the Chief Justice of Punjab and Haryana High Court. There were reports submitted by the Internal Audit Cell of the High Court, a report by the District and Session Judge Vigilance, reports and audit queries from the Accountant General's Office. In this background, it is stated even the Attorney General of India, Sori J. Sorabji, and the President of the Supreme Court Bar Association, Shri K. K. Venugopal, and other leaders of the bar met the Chief Justice of India, Sabyasachi Mukherjee, in open court and drew his attention to these reports. On 20th July 1990, CJI Mukherjee got up a few minutes earlier from the court, announcing that he would come back to make a statement. He did so after 4 p.m. The statement was widely published and is part of the Supreme Court record. When he came back to the court, the Chief Justice, after referring to the reports circulating about Justice V. Ramaswamy in his statement to the bar, the open court stated, and I quote, "This was an unprecedented and an embarrassing situation. It called for action and establishment of salutary convention. The Supreme Court must uphold the rule of law. It is therefore necessary that those who uphold the rule of law must live by the law, and judges must therefore be obliged to live according to law. We must therefore ensure that there is no conduct of judges which affects the faith of the people, that judges live according to law. I was constrained in these circumstances to advise Brother Ramaswamy to desist from discharging his judicial functions so long as the investigation continued, and his name was cleared on this aspect. Since I had assured the learned Attorney General and the Law Minister, the President of the Bar Association, and others that I will look into it, I thought I must convey this to you with the result of my looking into it." Unquote. Consequent to the advice, Justice Ramaswamy went on leave. This is an extract from an article, Judicial Integrity, Lessons from the Past by Anil Diwan, Senior Advocate, Supreme Court of India, published in Hindu, the 21st October 2009. When there was even rumors as to the probity of judge, if due care was taken by the Chief Justice concerned, like the steps taken by the former Chief Justice Sabyasachi Mukherjee, I think today the situation would have been different and would have sent appropriate message to other serving judges, as then the Chief Justice of India, Sabyasachi Mukherjee, said, "Those who uphold the rule of law must live by law." Therefore, the institution of judiciary itself must ensure that there is no conduct of the judge which affects the faith of the people, that judges live according to law. Everyone in the judiciary must understand that the existence of judiciary rests on the confidence of the people in the institution. There are very many instances which have come to light which indicates that because the people are not confident of getting timely and fair justice, extra constitutional bodies have come into existence for settlement of their dispute. It is true, judge and population ratio in India is pathetic. The working conditions of the subordinate judges till recently was pathetic. In spite of that, it is no excuse for the judiciary even to defend itself by saying either that they are short-handed or they do not have necessary infrastructure to dispose of the cases timely, because it is the duty of the judiciary to render justice in accordance with law strictly and timely. The enormous delay in disposal of the cases has delivered a body blow on the institution of judiciary. As Justice Krishnaiyer recently said, the problem of delay cannot be solved by increase in the number of judges, but it should be the appointment of quality judges also. In today's service condition, I think there are not many good honest lawyers who would refuse the offer of judgeship in the superior courts at least. The system of regional and communal representation should be totally abandoned in the selection of judges. Merit and integrity alone should be the criteria. I know nobody can disagree with the statement that merit and integrity should be criteria for appointment of judges in the judiciary. But I have to repeat this because this is not what is happening today. Consequences contrary to the above principle are disastrous. Let us note some of the recent instances that have come to light. In Chandigarh, some time back it is reported that a huge sum of money was delivered to be paid to one of the two judges who have their first name common. The inquiry body consisting of none other than the Chief Justice of the High Court found one judge guilty of misconduct. But on the opinion obtained from the Attorney General of India, the judge was exonerated, but the said judge was transferred to another High Court. Why is the question? If the judge is not guilty, of act of misconduct, this order of transfer should not have been made. If the judge is guilty, transfer will not be the appropriate punishment for such grave misconduct. There's one more case of a sitting judge of the Kolkata High Court, since resigned, for whose misconduct the Honorable Chief Justice of India recommended his case for impeachment. There's another case of Justice Dinakaran, which was also referred to the Parliament for impeachment, but both escaped impeachment by resigning from their post. We have yet another case of 34 judges of the subordinate High Court of Allahabad who are under investigation by the CBI for fraud in the Provident Fund belonging to the judicial employees. Some years back, there was an incident of a sitting judge of Allahabad High Court conducting a contempt of court proceedings in a railway platform because he was not provided with the railway berth to travel. Such examples are many. All this reflects on the process of selection of judges. Quicker the change in selection of judges is brought about, it will be better for the institution of judiciary. There should be an open debate in regard to what should be the method of change. I have referred to the above incidences not with any malice against any judicial institution of which I was a part for 40 years, but with a feeling of anguish, desire to bring about the change in the system. In conclusion, I must refer to one other institution which, even though not created by the Constitution, has attained the status of a fourth estate by its own performance and its own right. It has become like an organ of the Constitution, though not officially that is the media. In a democracy, media is the real voice of the people. It has played an important role over the years in creating public opinion. But recently, there have been some articles appearing in the section of the media itself which indicates the fall in professional standards, even amounting to corruption in media. The news item shows, for consideration, a section of the media has been indirectly canvassing for certain candidates during the election, mortgaging its independence. Since this type of allegation is in the preliminary stage, I appeal to the concerned people in the media to immediately take steps to put an end to such unacceptable practice. Lest there should be degeneration of probity in media, which in turn will have a disastrous effect on functioning of the democracy. As I mentioned earlier, democracy is the best form of governance. But democracy can survive only if the institutions created by its functioning within the parameters laid down by the Constitution. In my opinion, though democracy has come to stay in this country, there is a question mark still lingering about the degradation in values of the institution responsible for upholding the democracy. The optimism in me, in spite of the above, shows some light at the end of the tunnel. I hope it is not an illusion. Thank you, ladies and gentlemen.
Thank you, sir. Though it is not possible to put a price tag on your lecture and interaction with us today,